in the matter of Bathhill and Coletta.
Yes, Mr. Brown.
May it please the Court, together with my learned friend Mr Mark Green, I appear for the company, both the appellant and applicant in the two matters before you. My learned friends Miss Betsan Criddle and Mr Ben Jones appear for Mr Coletta. There is before the Court an application for permission to appeal no less than 2 years out of time, and a substantive appeal for which we have permission granted by Lord Justice Lewison.
Yes.
As the Court is aware, and Lord Justice Underhill in particular, there has been correspondence with the Court from the parties because the critical appeal in Royal Mencap and Shannon and Rampasad, which was determined by this Court last year, is to be determined by the Supreme Court. We understand now fixed for February 2020. So that, subject to us getting permission to appeal, would be of central relevance to determination of the appeal on the liability issue. We understand the Court's position, provisionally indicated by Lord Justice Underhill, to be that we should look at the question of permission to appeal out of time today. And
no, I don't think that's quite right. I thought we would not look at but decide the question of extension.
Forgive me, I didn't express that well. That is my understanding.
But if we are minded to grant, or if we would grant an extension, we would then postpone the question of permission until the decision of the Supreme Court. So I think it's what's on the agenda is extension.
Extension only, yes.
And we are relaxed as, I don't think, even if it were logically desirable, which I don't actually think it is, for us to decide that first before proceeding into the rest. I don't think that makes much practical sense. I don't know whether you, Ms Criddle, have decided which way to handle it, but I'd have thought we'd probably hear all your submissions on both points and then hear all of hers on both points.
If that's convenient to the Court, I'm sure that's convenient to both of us.
Yeah.
May I take it in what, with respect, seems to me to be the logical order, which is permission to appeal on liability first. There are before the Court two bundles, one on the liability permission application, one on the remedy appeal, and a supplementary bundle, and each side has lodged two replacement skeleton arguments addressing each question.
I am without a clerk, and as a result of that, I don't seem to have a supplemental bundle. I have the two cores, and I have a bundle of authorities. I have been brought a bundle in another case. That's probably my fault. Do I need the supplemental bundle?
I will want to refer to some facts in it. Your Lordship can probably get by without actually having it.
If that's all right, I'll look over my colleague's shoulders, or if there's a spare one in court, I'd be very grateful.
Oh, my friend has a spare.
Thank you. I'm sorry about that. I'm highly clerk dependent. Yes, thank you. Oh, yes, I have seen this.
So our application for permission is at page 13 of the core bundle on the permission side of the question. The application for extension of time.
Yes.
When applying for permission to appeal out of time, one is generally at a distance much less than 2 years from the decision which one is seeking to appeal. Something has normally happened which has put you out of time, whether it's illness or oversight or a change of mind. I have none of those points to advance to the court. The appeal turns on what difference the decision of this court in Shannon and Rampersad and Royal Mencap makes. And I accept that if, in the absence of those game-changing decisions, I were coming along 2 years out of time and asking the court to reopen what would otherwise be a closed transaction, then I would get quite short shrift. Lord Justice Lewison, with, it may be thought, some understatement, described the application for permission 2 years out of time as unusual. It is, but this is an unusual case. It's unusual in these critical respects that Royal Mencap has entirely changed the landscape. It has, subject to being upheld in the Supreme Court, rationalised and explained a confusing group of authorities as to what does and does not amount to work for the purposes of national minimum wage when someone is either asleep or at home. That wouldn't be enough by itself, but the case is unusual in this respect that it is still current. So although the liability decision was handed down over 2 years ago, the court is still seized of the matter, and it still has immediate financial significance to my clients who, if we cannot overturn the liability decision, must not only put up with the fact that they have paid £39,000 to Mr Coletta, but will also have to pay him in excess of a further £54,000. May I look, and this is the supplementary bundle, briefly at the financial position, and then I'll address the court as to why my client should have an extension of time, and on the basis of what, if any, conditions that extension might be granted. In the supplementary bundle, you have some evidence from Mr Coletta, who made an application which was disposed of by consent for protection from costs. So we are in a no-costs regime on both sides. I'm not sure a formal court order was made, but it is an agreed matter.
Yes, I know, grateful as I am for being given the bundle, it doesn't have section 3, which is, I suspect, the one you're referring to. I'm not being cross with anyone, it's very nice, I'm the one who's at fault, but oh, another copy coming up, yes.
We'll deprive Mr Green of his copy and see if that does any better. It says it has a section 3 in it. So. Is this the statement beginning, page 16? It is, my lord.
Thank you, Mr Green.
At paragraph 5 of that statement, he records the result of the Employment Appeal Tribunal decision in March 2018. At paragraph 6, I won't, unless the court wants it, read his detailed financial position into the record. We see that he received £39,000 odd for the 6 years of arrears. He then, at paragraph 7 and 8, sets out his financial position in between times. At 9, how he is now living, and at 10 what his current financial position
Yes,
is.
what we see that. What are you trying to get out of this?
What I take, and sorry, before coming to it, could I just go on a couple of pages to 21, where 20 and 21, where we have his tax calculation, and he has paid some tax on half of the amount he received, and he has said in his statement that he's expecting to pay tax on the remainder. Now, I recognise that the court is going to find, if I can put it like this, with respect some difficulty in the proposition that we ought to have permission to appeal out of time, an extension of time, so that if we succeed on liability, we would be entitled to go to Mr Coletta in those financial circumstances and demand repayment, potentially even with interest, of over £39,000. The court can, however, give us an extension of time subject to conditions. And what I would invite the court to consider doing is to give us that extension of time subject to the condition that we do not, even if successful, seek repayment of that sum of £39,545.24. That then holds the ring in a fair way between us, having allowed Mr Coletta to think for 2 years that he had that money to dispose of as he wished. He doesn't have to give it back, even if, on a proper understanding of the law post-Mencap, he shouldn't have had it in the first place.
Well, hang on, am I being slow here? Probably am. If Mencap survives in this court, or the decision of this court survives, the effect of that would be simply that he couldn't pursue his claim in respect of the more than £39,000. But doesn't that then mean that the substantive appeal that we're going on to hear becomes irrelevant?
If Mencap were to be upheld and subject to a point which my learned friend reserves, that she says Mencap is not necessarily dispositive of her client's position anyway, then the limitation appeal, the remedy matter, would fall by the wayside. But
and if Mencap were to be overturned in the Supreme Court, yes, I see. So it's in those circumstances, yes.
So if Mencap were to be overturned in the Supreme Court, I would want to have the benefit of a decision in my favour of this court on the limitation point, so as to knock out years 7 to 15.
I haven't woken up yet. So it's only academic one way.
Yes.
Okay, thank you.
So, as I've just observed, giving us that extension of time subject to that condition holds the ring, because although we've, on one view of the matter, sat on our hands for 2 years, we could have taken all those complex points based on the first report of the Low Pay Commission, which were ventilated in Mencap. Could have done that and didn't. So it would be, on this view of the position, fair not to upset Mr Coletta's status quo now and ask him to repay. However, if the court were to refuse us an extension of time, that is potentially productive of real injustice the other way, because on the hypothesis that Mencap is upheld in the Supreme Court, we would then be in and the further hypothesis that we lost on the limitation point, which is now before this court, we would then be exposed to paying Mr Coletta that further sum of £54,000 against a background where, as explained by the Supreme Court, we were never liable to pay him in the first place. Now, he hasn't had that £54,000 odd in his hands. We've had to lodge it with his solicitors as part of the price of a stay of execution. But if we're right on Mencap, and if the Supreme Court agrees that the Court of Appeal was right in Mencap, and if we were to lose on this point about limitation, we'd be paying him that £54,000 in circumstances where we were never in fact or in law liable to pay.
That's all just a consequence of the fact that you didn't do what you could have done 2 years ago, and sought permission to appeal to the Court of Appeal. These are interesting and subtle points, and you mitigate by your suggested condition an injustice that might otherwise occur. But why should you have the right to an extension at all?
Because the matter is still live before the court, because Mencap was debated in this court and illuminated what was otherwise a very difficult body of authority.
And all the more reason why you had a good chance on appeal.
Well, Mencap was dealt with without sparing of resources. There were, of course, 4 parties before the court in Mencap because there were 2 appeals. Shannon Rampersad was held back to marry up with Mencap ultimately.
I mean, Shannon, the employee, was the appellant.
Yes.
Whereas in Mencap, the employer was the appellant.
That's right. Mr. Shannon had lost
both levels.
Both in the Employment Tribunal and on appeal.
Yes, okay.
So the matter was debated in detail. There were, whatever it was, seven or 8 counsel, 4 parties, 2 interveners in a 2-day appeal in the Mencap matter. And we now know, subject to what the Supreme Court says, what the answer is. Your Lordship tests me by saying, well, isn't this just a consequence of you not appealing back at the time? To which the answer is, yes, it is just a consequence of us not appealing at the time. But the question I'd invite the court to ask is it really a just consequence if we are going to be put in the position, on the hypotheses which I've already sketched, of having to pay more money to Mr Coletta when we shouldn't be...
In a sense, that's just an accident. If the limitation point had... I mean, if it hadn't been split off, the remedy point, and you didn't have to pay the whole lot, then it's just a procedural accident. The limitation point is effectively to deliver the life of its own.
Yes. It's part of the procedural history, which is why the matter is before the court in circumstances where it might not otherwise have been. Don't misunderstand me. I don't criticise Mr Coletta for taking his appeal, but if he had won on his 6-year, he did win on his 6-year point. If he had stopped there, the matter would not be before the court at all. I would certainly not be trying to sustain an application when the matter has been done and dusted for 2 years. It ought to be reopened because Mencap is now has sorted out the law for us. But the matter is still live, and it can be dismissed along the lines of, well, it's just a consequence of you not appealing, or it's just a procedural accident. But that is merely to invoke history to explain why we are here. It doesn't actually address the justice of what should be done now, given that we are here.
Yeah, well, I see how you put it. Not that much more to be said, is there?
No.
No. Thank you very much indeed. Well, why not go straight on to the... We won't, as I said, we'll hear everybody on
Yes.
both points.
I'll go straight on.
Yeah, thank you.
So on the limitation appeal, we are concerned, this does not cover, if I can count backwards, years 1 to 6, going backwards. That's the £39,000, it's been paid, and we've discussed it. We are concerned with years 7 to 15, going backwards, seeking arrears of remuneration. I invite the court to have in mind, both during my submissions and perhaps more so during my learned friends, that this point has a very restricted scope. It's about a contractual debt. We're not dealing with claims under specific self-contained statutory regimes such as Workmen's Compensation Acts. Nor does this regime have any European influence, as does, for example, the working time regulations. We're dealing with a debt owed, if at all, under simple contract. We are not dealing with a proprietary claim where special provision has to be made in limitation to ensure that title to property is extinguished.
I appreciate this is one of the main points you're coming to, but I think I should just flag up, I'm quite sure Ms Criddle is not going to accept this is not a case where there's a self-contained regime. There is a self-contained regime, namely under Part 2 of the Employment Rights Act 1996. Yes. So I think, just to say, of course, this is one of the things you should note. It's not one of the things we should note, it's one of the things you're going to have to establish.
Well, the self-contained regime point under, say, the Workmen's Compensation Act provides for the recovery of the relevant compensation under the statutory regime. Under the National Minimum Wage Act, which is, of course, a self-contained regime as far as it goes.
Well, my point was about the Employment Rights Act.
I'm coming on to your Lordship's point. The enforcement is as a statutory, as a contractual debt, the contract being enhanced by statute. And under the Part 2 of the Employment Rights Act, the regime is there, as I shall submit in a moment, to adjust the account between...
Yes, I'm sorry, I wasn't trying to drag you more quickly than you would otherwise get to it, to the main point, but I just did think that I had to make the observation I did. But you carry on with your own path.
Thank you. May I remind the court first of the statutory structure of minimum wage? I appreciate that at least some members of the court are very familiar with it, and unless told otherwise, I'm going to take it pretty crisply. So the bundle of authorities has the first stuff in tab 9. So the core concept is that the individual is entitled to be remunerated at a particular hourly rate. That's in section 1.1. The type of work in which he's engaged and what counts as work is fleshed out in regulations, and we'll come to that in just a second. If he is not paid at the appropriate hourly rate, as worked out in accordance with the regulations, then section 17.1 provides that if he's remunerated at a lesser rate, he shall be taken to be entitled under his contract to be paid as additional remuneration in respect of that period.
Is that really all we need from the 1998 Act? Or is there more?
It's appropriate, I'd suggest, to see how enforcement fits in
If you say so, no.
it's with a 6-year limitation. So a notice of underpayment is the enforcement procedure which can be visited on the employer by HMRC, which is the statutory enforcer. And that's under section 19.
Yes, but just so that we're clear about this, the primary vanilla way of enforcing it is to bring a claim, is for the person who has been underpaid to bring a claim themselves. It is quite true, as you're about to show us, that HMRC also has a separate enforcement mechanism. You may know better than me how often it's deployed. It certainly sometimes is, I've seen it, but it's not the usual method.
I wouldn't, it may not matter, but I wouldn't, with respect, agree with that. I'm not sure that with respect, it helps the analysis of the statute to talk about primary vanilla ways of enforcing.
I think you're right. But we can agree about this. It is very common for employees just to bring their own claims.
Yes, the worker can bring his own claim.
Yep.
His claim, if he had to plead it in a Bullen and Leak kind of way, he would have to plead, if only people did in the Employment Tribunal, he would have to plead that he was employed under a worker's contract. Obviously he's a Lim A or a Lim B worker, and that he was underpaid by reference to the Act and the regulations, and so he is entitled under his contract to be paid by way of additional remuneration that sum. That's the legal underpinning of what he would be asking for.
I won't drag you forward into, if he chooses to bring his claim under Part 2 of the 1996 Act, he'd then have to say, and this is therefore an unlawful deduction.
Yes, absolutely.
Okay.
So if he's,
you were taking us to section 19.
Yeah, so we simply notice from section 19 that the enforcement officer can issue a notice of underpayment. We don't need to worry about the technicalities of that. The important point is 19.7. So there's a 6-year period for HMRC to enforce. And if I didn't say it, we can remind ourselves that if the employee sued in the county court for his Section 17 debt, he would, of course, be limited to 6 years because he's suing on a simple contract. Then simply, in order to see how the claim has, as it were, come up, the concept of what counts as work is fleshed out in the regulations, as I mentioned, behind tab 12. Relevantly, Mr Coletta was engaged in salaried hours work. The question is whether what he was doing when he was at home or asleep counts.
I'm sorry, having tried unfairly to put you on when you trying to show us section 19, do we really need to see how the nature of his claim under the regs? Everyone agrees he had a claim.
If the court's happy with that, I'm more than happy with that.
So, yes.
There was an issue about the hours, and that was determined in his favour. And we're now arguing about 6 years or 15 years. I'll move on.
I think so.
Thank you. taking the same hint, I will therefore pass over how those provisions were interpreted in Mencap.
Certainly.
So the next relevant provisions before turning, as I will in a moment, to Part 2 of the Employment Rights Act is the Limitation Act.
Yes.
That's behind tab 5. Part 1 of the Act, internal page 2, tells us that we are dealing with ordinary time limits for different classes of action. And at section 5, time limit for actions founded on simple contract. An action founded on simple contract shall not be brought after the expiration of 6 years from the date on which the cause of action accrued. If relevant, and it was treated as relevant below, section 9 gives us a time limit for actions for sums recoverable by statute, 6 years.
Just before we leave section 5, I don't think either party is taking a point, but you do flag it up as a non-point, that that proceedings in the Employment Tribunal are in principle capable of being an action.
Yes.
Within the meaning of section 5. I am not encouraging the parties to open up this point, but it might be something about which something might be worth saying in a judgment, perhaps. And therefore I did just want to flag up to you that there could be argument about that. I don't be unfair with even your great employment law knowledge to expect you to remember a case called, interestingly, Brennan and Sunderland City Council, which was about the application of the Civil Liability Contribution Act to claims in the employment. One of the issues there, since that used the language of an action, was whether that act applied to employment tribunal proceedings. Sorry, I'm doing this in a garbled way. One of the issues there was whether such proceedings were an action. And in the Employment Appeal Tribunal, myself presiding, we decided it wasn't. And that being one of the reasons. And we had been referred to various statements in the authorities about what an action means, and saying lawyers understand an action in a technical way to mean an action brought in the ordinary civil courts by writ, or I suppose in the county court by however you start a claim in the county court. Unfair to ask you to give any immediate reaction, but if we get to the short adjournment, as I suspect we will, might be something about which you might want to think in case you've got any observations. Sorry to bounce you with it now, but better to do it now while we're on section 5. And I have actually brought a copy of Brennan with me if you and your juniors would like to look at it. Not, I suspect, now, your junior might like to look at it now.
Yes, one observation I would make now is that we're not really concerned with the meaning of the word action because there's an interpretation section of 38 in the Limitation Act which...
It's a partial definition, isn't it? Yeah, sorry, yes, I'll let you finish your sentence, sorry.
Where action includes any proceeding in a court of law, including an ecclesiastical court. So what one would actually be looking at is whether a tribunal is a court of law.
That's a fair point. And I presumably that wasn't the case in the 1978 Act, at least if it was.
I'm sure that's right, but that's why I perhaps over glibly thought, well, obviously an employment tribunal in the modern era must be regarded as relevantly a court of law, judicially constituted.
I do obviously see the attraction of that, but for some purposes we do still distinguish quite carefully between courts and tribunals.
Yes, absolutely.
But there we are. Thank you very much indeed. That was a digression. You'd already have just passed on from section 5 to section 9.
Yes, I noticed section 9 as it seems to have been treated below as being the relevant limitation provision. It's not. This is a point of obviously of pure law, in which facts need to be debated. I'd suggest it's not obvious. Indeed, it's far from obvious that we are in section 9 rather than in section 5, because the sum which is recoverable by virtue of section 17 of the Minimum Wage Act is recoverable in the way that I've already addressed through the contract. There is no statutory right vested in the relevant worker to recover under statute. HMRC can help him under statute with the notice of underpayment, but that's not his right. HMRC has a discretion whether to issue a notice of underpayment. But his right is the contractual right as enhanced by section 17 of the Act. And then we need to notice section 39, which is central to Learned Friend's approach. Which is entitled Saving for Other Limitation Enactments. This Act shall not apply to any action for which a period of limitation is prescribed by or under any other enactment. So the core question for this court on the limitation appeal comes down to that very short one, whether that rolling 3 months that we're going to look at in Part 2 of the Employment Rights Act is fairly described as a period of limitation. And of course, if my learned friend is right, and I'll come on to develop this a little bit more in a moment, if section 39 disapplies section 5 for that contractual debt under section 17 of the National Minimum Wage Act, it has an odd result because there are 2 limitation periods. One for a claim in the county court and one different one for a claim under Part 2. And if she's right, then the claim under Part 2 can revivify a debt which is already statute barred at a stage.
Prejudicial way of putting it.
Well, with respect, my lord, it's not.
If you have two distinct ways in which you can claim, which is what I think she would say, to talk about course A revivifying something that's dead under course B doesn't. You're mixing the 2 streams.
Well, that's on the assumption that they are to be regarded as 2 streams,
yes, right.
rather than, as I present it, Part 2 being a way for the employee to control the way in which his employer keeps back contractual remuneration.
I can think of at least one other example of where there are separate limitation periods depending when you claim, and that's statutory holiday pay. Sorry, depending how which route you choose to claim under. Because I think I'm right in remembering, I'm afraid I should have looked this up before, but I remember because it's a case I was in, at least at an earlier stage, called Stringer. The House of Lords said you can claim under the regime which is in the working time regulations, which gives you 3 months from the non-payment of the holiday pay. But you can also claim under Part 2 of the 1996 Act, which gives you 3 months extendable if it's part of a series of deductions. So there you have, on the authority of the House of Lords, the same underlying claim, namely I haven't been paid my holiday pay, but with different limitation periods, depending on which route you choose to go down.
Well, as I prefaced my observations by saying that the regime we are looking at is an uncomplicated one. The working time is under which holiday pay
Yes.
will be payable is a particularly complex example which has with it European influences under the Working Time Directive and doubtless considerations of equivalence and effectiveness which simply do not arise in the minimum wage context, because minimum wage works on the basis of one statute with no European influence and currently one set of regulations.
Yes.
So it is an uneasy guide to say that under working time regulations with its European influence, this could happen in circumstances where what our regime is a contractual regime with, as I contend, a statutory bar to enforcement of the contract.
Thank you.
The next port of call is Part 2 of the Employment Rights Act. Which you will find behind tab 8. If I may interrupt myself for a moment, before going there, I'd like please to notice the other contractual enforcement procedure in the Employment Tribunal, on which my learned friend places some weight, which is behind tab 11.
Yes.
As the court knows, under provisions which are now to be found in section 3.2 of the Employment Tribunals Act, but were previously in the 1978 Employment Protection Consolidation Act, the Lord Chancellor may make regulations entitling, empowering the Employment Tribunal to hear and determine contract claims. And that was done by the Extension of Jurisdiction Order 1994, which is behind tab 11.
And the thinking behind it was this, that it was inconvenient and led to all sorts of waste, that in a straightforward case where someone was bringing a claim arising out of their dismissal, which was still then the most common form of claim, they might well have a claim for arrears, but they were told, well, you've got to go off to the county court for your arrears. So it was agreed to give the tribunal a jurisdiction to award contractual arrears in a case where someone had been dismissed, and up to a fairly arbitrary cap.
Yes.
Have I got that right? That is the history.
Arrears is probably not, with respect, the best example, because arrears could be claimed under Part 2 as a wrongful deduction from wages.
Quite right.
Other
contractual claim.
Yeah, a claim for damages for breach, for notice money, unpaid
Yes,
notice
quite
money.
right. Thank you for correcting me. But that in any event was the history. It was to avoid a dispute which was going to proceed in the Employment Tribunal.
We can't
one aspect of it having to go off to the county court.
Yes.
Thank you. Right, let's...
So we just notice at Article 3 of that order, proceedings may be brought before an employment tribunal in respect of a claim of an employee for recovery of damages or any other sum other than personal injury, if the claim is one to which Section 1312 of the 78 Act applies, and which a court in England and Wales would have jurisdiction to hear and determine. Section 1312 of the 78 Act, you won't find in the bundle, but it's now, as I've just observed, Section 3.2 of the Employment Tribunals Act 1996, and it relates relevantly to damages for breach of a contract of employment or for a sum due under such a contract. So you can bring a claim in the tribunal for contractual damages for breach of contract, or for a debt arising under the contract. And then there are conditions, and the relevant condition is at 3C. The claim arises or is outstanding on termination of the employee's employment. But that is obviously a contract claim. The Employment Tribunal is clothed with jurisdiction to hear it, so long as a court would have jurisdiction. So that's a territorial matter. It could not, I submit, sensibly be contended that the limitation which attaches to a contract claim is set aside in such a case. But Article 7 gives you the jurisdictional limitation on the tribunal's authority. So Article 7, an employment tribunal shall not entertain a complaint in respect of a contract claim unless it is presented within the period of 3 months beginning with the effective date of termination of the contract, so far as relevant. So on one view, you could say that's a limitation period. And on that view, you would say, well, there we are, that's a limitation period. You've got to get in within 3 months of your effective date of termination. And the Limitation Act is excluded by Section 39. But I would say that's simply the wrong way of looking at it, and it will be, when we come to it in a moment, the wrong way of looking at Part 2 of the Employment Rights Act. All that Section 7 is doing, Article 7, is restricting the jurisdiction of the tribunal. It is saying nothing about limitation. You can bring a contract claim before the tribunal, but you can only do so in restricted circumstances. One restrictive circumstance is that it has got to be outstanding on termination of employment. We've just seen that. And another, which goes to the jurisdiction of the tribunal to entertain it, is that you have got to have put your claim in within 3 months of the effective date of termination, subject to certain statutory possibilities of extension, which we don't need to trouble with.
So in respect of such a claim, what do you say is the limitation period?
6 years under Section 5. If the claim is outstanding on termination of the employment, there could be a breach of contract 5 years before, and the employee would be entitled to litigate that in the tribunal. 7 years before, he's statute barred. The answer to his contract claim is, sorry, you're statute barred because you are claiming under the contract. And that approach, I submit, is the correct approach to Part 2 of the Employment Rights Act, to which I will now turn. behind tab 8. So, part 2 is a reenactment, and I think without changes of substance, of what was in the Wages Act 1986, which itself has a history going back at least to the Truck Act 1831. It's one of those areas in which statutory employment law interferes with what would otherwise be freedom of contract, and it is designed in part to protect employees against the behaviour of employers who would withhold from pay sums allegedly due, for example, because of till shortages in retail employment and lots of other things, but the retail employment is quite a
Well, you're quite right, that is indeed the history. That's certainly entirely what the Truck Acts are about, and it's partly what these provisions are about. But as interpreted from the very early days, they are also simply a mechanism of enforcing non-payment of wages.
Yes,
And that was clear, been clear since Delaney and Staples.
I completely agree.
Yep.
But while accepting that, and with respect to Lord Brown Wilkinson, the decision in Delaney and Staples now looks inevitable because of the way the Act is structured, that any shortfall is to be taken to be a deduction. But although your Lordship's description of it as being a standard way of enforcing non-payment of wages is correct, it does not remove the underpinning of the necessary legal relationship between employer and employee, pursuant to which those wages become payable. So you can't forget that there is a contract, and it is that contract which is being enforced when the employee seeks payment of unpaid or underpaid wages. So may I look through part 2 and just make some comments on some of the provisions as we go. Section 13, an employer shall not make a deduction from wages unless there are various ways in which he can get it authorised, relevant provision in the contract and so on. And then section 13.3, this is why I observed that Delaney and Staples seemed pretty inevitable result, where the total amount of wages paid on any occasion by an employer to a worker is less than the total amount of the wages properly payable by him to the worker on that occasion, the amount of the deficiency shall be treated as a deduction. So if non-payment is still a deduction. We can leave section 14. We notice section 15, which is the other barrel to this element of protection. So the employer can't deduct from what he's paying you, and he can't require you to make payments to him. And there are exceptions to that. Various points about timing that we don't need to worry about. Notice at section 22 a definition of final instalment of wages, and that definition at 22.1a relies on the concept of contractual remuneration in respect of the relevant periods. And before coming back to the critical points, section 23, the enforcement provisions, could I go on to the definition at section 27? In 27.1, in this part, wages in relation to a worker means any sums payable to the worker in connection with his employment, including ... any emolument referable to his employment, whether payable under his contract or otherwise. Now that or otherwise justifies a moment's thought, because...
You just read a phrase I can't see. 27...
Section 27.1a,
Yeah.
and sorry, I left out some words for brevity, but I overdid it. So it's emolument payable under contract or otherwise. One should not, I submit, make the mistake of thinking that that allows some sort of vagueness as to the legal underpinning of the entitlement. It's best seen, I'd suggest, as anti-avoidance in this sense. Consider an employer whose employee is entitled to wages of 100 and a bonus payable indifferently to everybody in the relevant workforce of 20, and the employer deducts 15, the employer cannot, by way of defence, say, I haven't made a deduction from what is properly payable to you, because what I've done is withhold from the discretionary bonus.
Well, there's been some law about this.
Yeah.
There's a case called New Century Church.
Yes.
I did think, well, I'm not quite clear what your opinion on it. If your opinion is something important on it, perhaps we would need to look at it. But I hope not.
The point I want, the point I'm maintaining, and I'm diverting so as not to be diverted later, is that in order to decide what is properly payable, you have the employee, in our case, has to rely on his contractual right. And that point about what is and isn't wages is something which is more explicit in the statutory predecessor, which is the Wages Act 1986. And you will see a provision at section 7.3.
You want us to look at that?
Yes.
I see you have given us the wages.
It's behind tab 7. Just won't take a moment. This is the meaning of wages in the statutory predecessor. Internal page 8 and tab 7. Meaning of wages, and we jump to subsection 3, where any payment in the nature of a non-contractual bonus is for any reason made to a worker by his employer, then for the purposes of this part, the amount of the payment shall be treated as wages and treated as payable to him as such on the day in which the payment is made.
Why are you taking us to that in the Wages Act? Because it's also in the in part 2, isn't it?
If it is, then I overlooked it.
I think it's section 27.3, isn't it?
It is identical terms. I'm sorry, that's my mistake. I'd identified it in the earlier statute and overlooked it in the relevant one.
Don't worry.
The point I take from it is that payable under your contract or otherwise is best seen as an anti-avoidance provision, and it doesn't detract from the importance of identifying the contractual underpinning of the individual's entitlement.
Yes.
If the court would go back to section 23, we can look at how enforcement actually works. A worker may present a complaint to an employment tribunal that his employer has made a deduction from his wages in contravention of section 13. That is then subject to the, as I would term it, jurisdictional limitation on the tribunal, similar to the one that we've just looked at in respect of the extension of jurisdiction order. That the tribunal shall not consider the complaint unless it's presented before the end of the period of 3 months, beginning with the date of payment of the wages from which the deduction was made. Subject again to various statutory extensions. So when deciding that a complaint under section 23, what the tribunal has to ask itself is, was the total amount of wages paid less than the amount of the wages properly payable? That's the statutory question raised by section 13.3. And in order for the employee to establish his case that there was a shortfall in what was properly payable, he has to invoke the contract. That's the core point. He has to say, I am entitled, was at that date and still am, entitled to a contractual debt under my contract of employment as enhanced by section 17 of the Act, National Minimum Wage Act. And if that item of debt accrued more than 6 years ago, my submission, this jurisdictional feature of the Employment Tribunal has nothing to do with limitation. The debt is statute barred after 6 years, and though your lordship didn't care for my description of it as revivifying it, he's in Mr Coletta's own case, a debt which accrued 15 years ago became statute barred 9 years ago. Then, after waiting 9 years, he launches his tribunal proceedings, and as I submit, the correct way of looking at it is, he's saying, I am entitled, because it is properly payable, was properly payable at the time, to the value of the debt. And my submission is that that debt is statute barred. In section 23 of the part 2 of the Employment Rights Act simply says nothing about how far back arrears may be enforceable. What they tell us...
Well, it does, doesn't it?
Well,
it says they can be enforceable as long as they're brought within 3 months of the last deduction, or where there's a series of the deduction, or where there's a series within 3 months of the last deduction. So
well,
doesn't that tell you how far you can go back?
That tells you how soon after the last deduction he must lodge his claim.
Well, isn't that what a limitation claim is?
In order for the tribunal to have jurisdiction to consider it at all. When the tribunal, because he has various ways in which he can enforce. If he wants to choose this one, he's got to make a claim within 3 months. subject to extension. And if he doesn't do that, the tribunal simply may not consider his claim.
Well, it's the same under the Limitation Act, only the difference is it's 6 months, it's 6 years rather than 3 months.
But Section 23 isn't telling you anything about how far back he can go. It's saying what the tribunal can do in order to permit him to enforce his debt. The tribunal must close its doors to him if he comes along after 3 months. He can still go elsewhere if he's in time. So, my submission is that Mr Coletta's arrears are not recoverable under Section 23. They are recoverable by virtue of his contractual right. And his contractual right is barred by Section 5. And that's the...
That's really the point.
That's really the point, yes. Although the tribunal pinned it on Section 9 rather than Section 5, the point is effectively the same one. And
just hang on 1 second. Yeah.
And the particular point of difference that we have with the way in which Her Honour Judge Eadie dealt with the appeal against the Employment Tribunal's decision was for her to say that Section 23 imposes a limitation period in the sense in which that term is used in the Limitation Act. Section 39 of the Limitation Act is, I submit, doing something rather different. It's saying, take an example like a sum recoverable by statute. A sum recoverable by statute is recoverable subject to a limitation period of 6 years, that's Section 9. However, there are all sorts of areas in which sums may be recoverable by statute, but subject to other periods of limitation. For example, there's something the court may have come across as the 4-year cap in VAT. If you've overpaid VAT and you go to HMRC and ask for it back, you are caught by the 4-year cap, and you can't have a repayment going back more than 4 years.
Why isn't this a 3-month cap?
Because it says nothing about how far back you can go. If it was a 3-month cap, then the problem for my clients would not be very acute. The problem that they have is that it's being treated as a 15-year cap.
Well, it's being treated as an indefinite. Can be 15 years here.
Yes.
That's your point.
Exactly, and it's an indefinite and shifting cap. So, so the a sum may accrue due 10 years ago, and it's a contract debt, and it's looking only at Section 5 of the Limitation Act, it is statute barred. But whether it remains statute barred, if the EAT is right, is entirely a movable feast. It depends not on that debt, that date of accrual, and whether that debt was being enforced. But
whether the employer goes on wrongfully deducting it to adopt the language.
Well,
what's wrong with that? As a sensible construct or as a policy?
Well, as a policy approach, it means that nobody knows what the position is. So I made the point in writing that businesses and companies, flats in the case of my clients, change hands. They may change hands because of a share purchase. They may change hands because of movement of the employees between businesses under the transfer of undertakings regulations.
That could happen if there's a contractual limitation period of 6 years, and that was the only relevant one. You could have just that problem just as much. I appreciate, of course, the longer back you go, the greater the chance that records will have been lost. But there's no magic about 6 years. You could have just the same problems if it had been sold 4 years ago to somebody else and they didn't give you the records.
But that's the policy decision. There is an element of policy decision making in all of limitation. Parliament has taken the view that for some types of action, 6 years should be the backstop. For others, 3. For others, should maybe discretionary extensions and so on. But these provisions, if interpreted in the way that the Employment Appeal Tribunal interpreted them, allow a debt to accrue at a date, a specific date identifiable by reference to Section 17 of the Minimum Wage Act. And then, as I submit, whether that debt became statute bar or not doesn't depend on the passage of time after accrual of that debt, but on the accrual or not of other debts at other later dates.
Mr. Brennan, can I just, forgive me, just go back to an earlier point. Can I just clarify this? In respect of Section 13.2 and the stipulation of 3 months there, do you accept that is stipulating a limitation period?
Not in the sense in which it's the term is used in the Limitation Act. It's the distinction to be drawn is between delimiting the jurisdiction of the Employment Tribunal to entertain a claim and a limitation period. And what one would expect to find in respect of a limitation period is a provision that says no cause of action in respect of a particular legal liability may be commenced more than.
But that's just what this does.
Yeah.
It's just 3 months rather than 6 years.
But it's not addressing the historic position. There's a 3-month claim, forgive me, a 3-month period which entitles the tribunal to engage with that debt. But the provision doesn't tell you anything about how long after accrual of the debt, the accrual of the cause of action.
If we leave out the series of deductions point, it's quite a useful thought experiment to do that first, you still haven't explained to me why this isn't exactly the same as a limitation, as the operation of the Limitation Act, which says no claim may be brought more than 6 years after the accrual of the relevant cause of action. And Part 2, Section 23.2 says no claim may be brought more than 3 months after the accrual of the relevant cause of action. They're doing the same thing in the same way.
No, it's jurisdiction specific. That's the point. Could I ask this?
Well,
So this tribunal, the Employment Tribunal, may not engage with it. But the...
Well, it's implicit. I mean, if you were to take any of the provisions in the Limitation Act, whether it's contract or statute, it's implicit because it refers to an action being founded in a court or instituted in a court. All this is doing is identifying an employment tribunal. It's exactly the same premise.
But you would, I submit, expect a limitation provision to take effect across all the forums in which the right may be enforced. It's right specific, not forum specific. So this is restricting the jurisdiction of the tribunal to engage with the point. It isn't restricting enforceability of the debt. You can go somewhere else and enforce the debt somewhere else. So one has to ask the question, if this approach is to be taken, what is the limitation period applicable to a debt in simple contract? And you can't, on this approach, give one answer.
without getting too historical about it, if you go back to 1623, which is really where this formulation in the 1980 Act comes from, there was only one place you could go, the King's Courts. So it was also jurisdiction specific. The two were the same thing. You can't enforce your claim. It's quite true this is jurisdiction specific because it's a claim that a special jurisdiction has been created for, namely the Employment Tribunal. But so is the Limitation Act jurisdiction specific. It's to do with enforcement in the King's Courts or any court of law.
But it's not, with respect, the very way your Lordship puts it. It's not to do with enforcement in any court of law. It's enforcement in some courts of law, but not others. And that is what I submit is inconsistent with this being a limitation period, because you cannot answer the question, what is the limitation period applicable to a debt in simple contract arising under the contract of employment? You would have to say, well, it all depends. And that, I submit, is not consistent with it being a limitation period. And neither, of course, is it even expressed by way of, by reference to time.
I think
Mr. Baker, can we test it this way, so that I understand what you're saying? If let's take not the series, but the single claim. The single claim in respect of a wrongful deduction 8 weeks old. Right. 8 weeks ago.
Yes.
If that claim is issued in the Employment Tribunal, provided it is a contract claim, a claim under the contract, what is the limitation period?
The limitation period in contract is 6 years. The jurisdiction of the Employment Tribunal to determine that contractual claim is undoubted, because the claim is commenced in the tribunal only 8 weeks after the cause of action accrued.
So it's a contract claim with a 6-year limitation which can be invoked for a shorter period before the Employment Tribunal.
Yes.
If the claim is not a contract claim, if it in fact is a statutory claim, then what's the limitation period? I appreciate you don't start from there, but if one did start from there, would you accept that the 3 months then would be a limitation period?
No, the Limitation Act says that the limitation period applicable to a claim for a sum due under statute, one would want to be quite careful about what the statute is, but let's park that for a moment, is 6 years. So that's the limitation period in each case, whether it's Section 5 contract or Section 9 statute. And the tribunal undoubtedly has its jurisdiction to determine that question, because that's what Part 2 of the Employment Rights Act says.
So the analysis you say is it doesn't matter whether it is a claim under contract. This is the single claim in relation to 8 weeks before 8 weeks ago. It doesn't matter whether it's contract or statute, because in either case the limitation period is 6 years, different provisions of the Limitation Act, but the jurisdictional time during which the ET can receive such a claim is 3 months.
Yes, and if you miss the 3 months, subject to irrelevant extension provisions, you can still go somewhere else and enforce your claim, if it's a contract claim or subject to the terms of the statute.
It depends on saying they are different claims. You will have some claims which only exist under the statute and have exactly the same model. Let's take a statutory holiday pay claim. That doesn't have, I think, tell me if I'm wrong, the mechanism of the statute saying you must read this right into the contract. It's purely statutory, right?
That wasn't the case up until the regulations changed after Bear Scotland in order to introduce the 2-year provision.
Well, all right. I may have chosen a bad example, and Ms. Priddle may have to give us a better example. But I'm pretty sure that there are statutory pecuniary liquidated claims created where exactly this model is used. You create the right, you give jurisdiction to the tribunal, and you say that you create what I will call, but you'll say I shouldn't call, a limitation period of 3 months. Just ignore the series point. Your argument wouldn't be available to you then, would it? Because the statutory right and the jurisdiction to enforce that right are completely intertwined.
They may be, which is why I prefaced my submissions by saying you've got to be careful at looking at the rather plain structure of the Minimum Wage Act and Part 2 of the Employment Rights Act. We are not dealing with a separate, self-contained statutory regime. We probably don't want to get into the complications of it, but equal pay, for example, operates through contract, but there's a statutory arrears period, and
well, that, as you say, that's a whole other ballgame. I'm trying to put to you a straightforward claim, which certainly there must exist conceptually, even if nobody can think of an example of it, but the statute creates the right. It's a right to be paid a liquidated sum, and the tribunal is given a jurisdiction to enforce claims for that right, and that's limited in point of time. You can't then say, oh well, you separate out a limitation on the right from the limitation on the jurisdiction of the tribunal to enforce that right. The two are just the same thing.
well, they may very well be so closely entwined as not to be susceptible of this analysis. But if you have a statutory right which is justiciable only in the Employment Tribunal,
Yes.
and the only way you can get it in front of the tribunal is to bring your claim within 3 months of a relevant strike date,
Yeah.
and you don't do that, then you are out of court anyway. It will not help you to say, well, I've got 6 years, I've got a theoretical, virtual, as it were, 6-year period, because the tribunal in this hypothetical example has the exclusive jurisdiction to enforce your right, and you've missed the
Yes, quite.
date. But it's then not
So
interesting.
then the 3 months is a limitation period.
Well,
You
you
can't make a claim after 3
it
months.
may have the effect of being a limitation period, which effect is brought about by prohibiting the Employment Tribunal from engaging with the claim. Because if the tribunal, it might turn on just how it's expressed, but if it's the conventional phraseology that we're familiar with, the tribunal shall not consider a claim brought more than 3 months after such and such a strike date. In such a situation, it doesn't actually matter whether you can point to Section 9 of the Limitation Act and say, I've got a 3-year limitation, because...
No, but we're dealing with what the concept of a limitation period means. And the reason that I'm putting this example to you is the one that my lord picked up, that in that type of example, anyone would say that the 3 months is a limitation period. But I think you have to say no, and you did say, no, it's got the effect of being a limitation period, but it's not a limitation period in the sense that normally people understand that phrase. It's actually only a condition of the jurisdiction of the tribunal. That's how you put it.
Yes, that is how I put it. And I accept that in, if I can put it like this, casual speech, you might say that the individual is barred through expiry of a limitation period. It's not in practice how employment law tends to work, or employment lawyers tend to think, and it's somebody missing his...
You'd probably say, are you taking your time point, Mr. Brennan? But you might say, are you taking a limitation point? I think you might well. Okay.
But you see, you've used the word, in answer to my Lord's question, you've used the word effect. It is really the result. And the result is the same, isn't it? In this example, applying section 23(2, in the same way you apply the time limitations in either section 5 or section 9 of the Limitation Act. You can use the word effect, you can use the word result. It's exactly the same.
If the court is content with the analysis that there may be two limitation periods for the same right, then it may be driven to that conclusion. My submission is that if you're going to identify a period of limitation relevant to a contractual right, you need to identify by descriptional formula when that period starts to run in respect of that particular chosen action and when it expires. And that's what you get from section 5, and it is not what you get from regarding the 3-month period referred to in section 23 as a limitation period. The better description is, I submit, a restriction on the jurisdiction of the tribunal.
But that does depend on what the right is. If it is a contractual right that can't be brought in, if that's what it is, you're suing for a breach of your contract, if that's right. And you can't sue in the Employment Tribunal because you're more than 3 months beyond the single date when it accrues, then that 3 months does not debar you from suing for that debt elsewhere. That's your point.
Yes. And my question, rhetorically, following on from that, is what's the limitation period applicable to that debt?
Well, the answer to the question, I speak personally, speak myself, is 6 years. But that begs the question as to whether the right to sue is a contractual right or whether it derives from the statute. If it derives from the statute and what you can pursue in the county court is a contractual right which is different, then that separates the two.
But
Either it's an underlying ongoing contractual right. For a period you can use the ET as your jurisdiction. For a period you can't. Or it's a statutory right, in which case how do you extend the limitation period beyond the statute that gives you the right?
But in our case, Part 2 of the Employment Rights Act gives a statutory right to go to the tribunal to enforce something. We'll accept that. But that which is being enforced is a right in contract.
Well, that's what you say. That's really the heart of the argument.
That's the fundamental point.
Yes.
Can I just draw out one point? I'll say frankly, I'm not sure is a helpful point to you, but might appear to be a superficially helpful point to you. You can look the gift horse in the mouth or not. I was taught at an early stage that although the language of the Limitation Act looks rather like a jurisdictional point, it isn't, and that if the defendant doesn't plead, the claim isn't barred.
Yes.
So actually you can bring a claim for nine years, and if someone's foolish enough not to claim 9 years after the debt's accrued, not to take the point, tough, and there are certain circumstances where you can deploy it by way of set-off and so forth. Does that help you, or is it neutral?
I suggest it probably helps me to a small extent. A classic limitation defence, I respectfully accept what your lordship says, has to be taken by the defendant. A jurisdictional bar to the proceedings does not have to be taken by the defendant, but must, if it applies at all, be taken by the court or tribunal. And, my learned friend refers in her skeleton to some observations of Lord Sumption in the minority in Abdullah. No doubt you'll go to it, but it's tab 30. And he says, well, it may not really make very much difference to say whether it's a limitation point or a jurisdiction point. It really only goes to the question of whether it can be waived.
Yeah.
But I'd submit it goes a little bit further than that. Lord Sumption was probably not engaging, well, was not engaging precisely with what we have to grapple with here. You would expect, I'd submit, to find in a limitation defence something which can be waived, or which, I put it the other way around, a limitation defence has to be taken.
Yeah.
Whereas if the limitation period which is alleged to be in existence in section 23 of part 2 is not such a thing. It's a jurisdictional bar on the tribunal. It's not something which is there for the defendant to take or to waive at his option.
The practice in the employment tribunals, in my experience, is that they very rarely take time points. They leave it up to the parties to do it.
Well,
Partly
yes.
because it's always extendable anyway.
Yes, and partly also because parties very rarely fail to take a time point.
Quite.
Never engage with the
Okay, well,
merits
that's
if you take a
perhaps
time point.
that doesn't help us. Well, thank you. I just wanted to see how that fitted into your argument, and I see how it does. Now, we've gone over pretty well all of it, haven't we?
That was, with respect, my impression as well, my lord. Unless I can offer your lordship anything else which looks like assistance, I'll...
No, well, let's hear from Mr Criddle.
Thank you.
Yes, Mr Criddle. I wonder whether it might make sense, if this isn't inconvenient to you, to deal with the substantive point first.
Very content to do that.
That we all wrote in our minds.
And then I'll return.
Then you can come back to the extension point. Yeah.
The extension point. I had, in fact, prepared my speaking remarks in that way.
Good.
So it's very convenient to me. Madam, can I start in this way, with this observation? The case being advanced by the appellant has shifted very considerably before this court from the case that it ran before the Employment Tribunal and before the Employment Appeal Tribunal. Before the Employment Tribunal, it was common ground that Section 9 was prima facie, in any event, the relevant time limit in the Limitation Act. And I'm going to talk about time limits because that's what the Limitation Act talks about. Every section is described as a time limit in exactly the same way as Section 23 describes a time limit for a deductions claim. But the second point is this: it was conceded before the Employment Appeal Tribunal that Section 9 was disapplied by Section 23(2) of the Employment Rights Act because that Section 23(2) was an alternative provision in respect of limitation in the case of a single deduction from wages. And this, I think, will be the only time I take my lords and my lady to the EAT judgment. That's probably being foolish. But it's page 53 in your remedy bundle. Discussion and conclusion of Her Honour Judge Eady starts immediately prior at page 52, but she says, she notes this at paragraph 44, page 53. Having regard to subsections 23(2).
So sorry, I was looking at the wrong decision of the EAT, but I'm catching up. I was looking at the wrong bundle. Yes.
Having regard, she says, to subsection 23(2) to 4 of the Employment Rights Act, the answer seems to be clear. A limitation is thus placed on unauthorised deductions claims by virtue of section 23, such that an ET can only consider a complaint presented before the end of a period of 3 months, beginning with, I paraphrase, the deduction issue. That being so, the simple answer would seem to be that section 39 LA applies and section 9 does not. Indeed, as Mr Green for the respondent volunteered in argument, if a claim for these purposes was limited to a single deduction, no issue would arise. The respondent would accept that Section 23(2) of the Employment Rights Act prescribes a period of limitation of 3 months beginning with the date of the deduction. So the answer to my lady's question to Mr Brennan a moment ago in the EAT would have been yes, we do accept that Section 23(2) is a time limit, it's a period of limitation, at least in the case of a single deduction. And at no point in the skeleton, in the notice of appeal and skeleton argument, or indeed Mr Brennan's remarks now, is that concession acknowledged. Even less is there any explanation as to why the appellant now seeks to depart from it. And it is, of course, as the court will note, fundamentally inconsistent with the case that Mr Brennan is now advancing before this court, what it describes as its core challenge, namely that the time limit in Section 23 is not actually a limitation period at all. It may look like a limitation period, it may sound like a limitation period, but actually it's not a limitation period at all. It's something rather different. It's called a jurisdictional restriction. You will look in vain anywhere for the term jurisdictional restriction certainly in the statutory language, or indeed in the authorities. And therefore, in my submission, the first issue, in fact, for this court, is accordingly whether to allow the appellant to put the argument now on a different basis, which is that Section 5 is prima facie the relevant time limit, and Section 23 isn't at any point an alternative provision for limitation, whether you're concerned with a single deduction or a series, and that, it seems, breaks down to 2 points, although, if I've understood Mr Brennan correctly, he puts more emphasis on the first. He says it can't be a limitation period if it bars remedy only. It can only be a limitation period if it bars remedy only, otherwise it can't be. And also what seems to be the secondary point, that you have to have a prescribed period. You have to begin with the accrual of the cause of action. You have to end after an identified period of years. In the authorities bundle, and I wasn't proposing to take the court to it unless you particularly want me to do so, there's the case of GLAT on when a party may or may not be permitted to depart from a concession. But in my submission, the starting point must be for Mr Brennan to explain to you why he should be allowed to resile from the concession that was made below before anything else arises. But in any event, I accept...
So you're not going to get a ruling out of us on that now,
no,
so I think you better assume he's going to be, if he has to, he's going to be allowed to withdraw from his concession.
And I accept, of course, that this is a pure point of law, and that, of course, is going to weigh heavily in the analysis with this court. I assure you that what's in front of me on the screen does not stop with, please don't let Mr Brennan take this point.
It may be that you've never had the experience of leading counsel coming in and the focus of the argument changes, but some of us have.
Well, my lord, I'll say no more about that. But in any event, in my submission, the concession was correctly made before the EAT, and the logic of that concession is that it applies with equal force, whether one is looking at a series of deductions. Whether this is a Section 5 claim, or whether it's a Section 9 claim, and I do say, and I will develop this, that Section 9 is the applicable prima facie time limit, then an alternative provision as to limitation is made by Section 23. And if I can quote for a moment Professor McGee, and I will take you to the textbooks which speak with one voice as to this point, which is the time limits in the employment sphere are limitation periods. Professor McGee describes a limitation. He says a limitation period is construed as including any provision which specifies a time limit within which legal proceedings of a particular kind must be brought. That is what we're talking about here. It doesn't get much more difficult than that. There is a time limit, there is a limitation period. It starts with the date of the deduction, or as the case may be, the last in the series of the deductions, and it ends 3 months later. However, before I turn into the argument about Section 9 and about Section 39, there is the point that my Lord Justice Underhill raised, which is that of the Brennan case. Because for this case, even to engage the Limitation Act at all,
I have given away all my copies. I thought I kept one. No, I will get one back from one of your juniors, whichever.
yes,
Mine is highlighted, I'm afraid.
That doesn't worry me.
As is mine, as
I don't mind having it highlighted, unless it says rude things about the judge, and that will be interesting too.
you will see what Mr Jones considers to be interesting about the Brennan case. Because if one turns for a moment into the Limitation Act, just to make good points, the Limitation Act has at section 38 an interpretation section. Forgive me, it's behind tab 5 if you're referring to something.
Yep.
And at section 38 of the Limitation Act, it says that by subsection 1, in this Act, unless the context otherwise requires, action includes any proceeding in a court of law, including an ecclesiastical court. And then it refers to subsection 11 before, a bit below, but that doesn't trouble us for present purposes. And therefore, what one sees used throughout the Limitation Act, and that includes section 5 and section 9, is the reference to an action.
Yes.
And then we know from the interpretation section that includes any proceeding in a court of law.
Yes. But perhaps I'll just say this, Ms. Criddle. Not every point that the court thinks of, which counsel haven't thought of, is good. Indeed, frankly, you can't say this, but I can. There's a presumption it probably isn't, or counsel would have thought of it. So, if this is a bad point, you don't have to run with it. And certainly the point, the simple point that occurred to me about the definition of action without a definition is undermined by Section 11, isn't it? We're in different territory here. You may still want to make a point about it.
Yes.
Sorry, I say Section 11, Section 38,
Yeah.
1.
I think, my Lord, that the position under the Limitation Act may be slightly different to the point that your Lordship was dealing with in Brennan, because in Brennan you were concerned, or the EAT on that occasion was concerned both with the definition of action and it was concerned with the definition of a court. But the point relating to court is one that is dealt with by you and your members in the EAT, and it starts at 1193, paragraph 22. So at paragraph 22, the submissions for counsel for the unions are recorded, and then subsection 1, you referred to the definition of an action, but then over the page at subsection 2, in relation to court, we were reminded that when the legislature means that term to cover tribunals, it says so expressly, and you were referred to various sections. Otherwise, the terms court and tribunal are recognised as distinct. Mr Miller pointed out that the 1996 Act expressly designates the Employment Appeal Tribunal, but not the Employment Tribunal as a court of record. The unions also took the point that the Employment Tribunal's Rules of Procedure 2004 contain no provisions equivalent to those of Part 20 of the CPR, under which a contributing claim may be brought, and so on. And then Mr Reid for the employer said that the unions were being unduly narrow and technical, and at paragraph 24...
and we pick up at 23.1 that in a different context, an industrial tribunal has been held to be a court in the context of So it may not be straightforward.
It may not be straightforward, but you do go on at paragraph 24 to prefer the union submissions. The natural reading of the sections on which they rely is indeed that the 78 Act is concerned only with claims justiciable in the ordinary courts. No doubt the use of the words court in action is not conclusive, as the case is referred to by Mr Reed shows. You were acknowledging that you could define it more broadly. And it would be possible to construe them expansively if the context showed that that was the intention of Parliament, but we can see nothing in the context to suggest any such intention, or that the draftsman was not using the technical language that he did in the sense which would normally be understood by lawyers. And then you go on as well to look at the legislative history. And then at paragraph 25, the construction is consistent with the conclusion on the issue of jurisdiction. So I would, if I can put it this way, say that you were absolutely right to bring this case to the to the attention of the parties, and that in the absence of anything within the Limitation Act to suggest that an employment tribunal was intended to be a court of law for these purposes, then the Limitation Act simply is inapplicable. So if I'm right about that, then of course one is not concerned with any of the technicalities of, is it section 5, is it section 9, is it disapplied by section 39. But if you're against me on that, then of course I must go on and address the argument as formulated. So to start off with, is it section 5, is it section 9? The court might say to me, why does it matter, Ms Criddle? Because if we're into section 5, it's a 6-year limitation period. If we're into section 9, it's a 6-year limitation period. The reason it matters, of course, is that Mr Brennan is at pains to try and seek to persuade you that this is a contract claim. It is not a contract claim. It is a deductions claim. But that is why it matters, because he says it matters. And he says it matters because he says that you cannot possibly have two different limitation periods in respect of the same cause of action, to which I will say in due course, well, why ever not? Because there's nothing in section 39 that says you can't, and there are plenty of examples in which you do. You will, of course, have my point that the case was approached in the ET on the basis that these were proceedings for a sum recoverable by virtue of an enactment. That's the language of section 9, and specifically the Employment Rights Act, and that wasn't challenged by way of a cross appeal by the appellant in the EAT. But this is, as I say, a claim brought to recover a sum by virtue of an enactment, because it's brought as a deductions claim under section 23.
Can I just mention this in passing? In the Employment Tribunal's judgment, no need to go to it, but it's paragraph 22 and it's the last sentence. It was conceded that had the claim been presented as a breach of contract claim, then the limitation period would apply. So it was absolutely clear before the ET.
If it had been,
yes,
but
precisely
it was not, my lady, you're
yes,
precisely
but what I'm
right.
seeking to identify is the point you've been making, namely the base nature of the claim.
The base nature of the claim, my lady, you're absolutely correct about that. Mr Jones and I were congratulating ourselves on having managed to create a bundle of authorities with the Truck Act in, because I don't think either of us thought we'd managed that particular feat before. But the Truck Act is the genesis of deductions legislation. It predates the Employment Tribunal's limited contractual jurisdiction by over 160 years. And if one goes right back to the Truck Act has some quite distinctive features to it. Section 4 of the Truck Act is the provision that says you must be paid in money. You can't be paid in goods, you can't be paid in any other way.
And can we congratulate you not only on giving us a copy of the Truck Act, but giving it in a nice printed copy instead of something that's come off the internet.
Right,
It's both more fun and easier to read.
we try our best to please the court. But at section, so it's at section 4 that says that you're entitled to recover from your employer your wages in the current coin of the realm. So it was designed to stop situations in which the employer would pay you by way of goods or say to you, here's a voucher and go and spend it at the company shop. You had to actually have coin in your hand. But section 5, and this has survived, is that the defendant is not allowed to set off anything against your entitlement to wages. You have your entitlement to wages, and that it cannot be set off. You cannot claim any reduction in respect of goods, wares, merchandise, and so on. And this has always been a very distinctive feature of deductions legislation. And my lord, you probably don't recall the case of Aziz that you presided over in the EAT, in which you made precisely that point in relation to a modern deductions claim. Aziz is at tab 27 of the authorities.
Well, I certainly wouldn't have called it, but I did have a quick look at it this morning. It's a single sentence, isn't it?
Indeed, but it was, it's paragraph 18. You say, as I read the reasons as a whole, this is the judge, was making one or both of 2 points. A, that the appellant was disentitled to relief because he had himself not fully performed his side of the contract. B, the respondent had a cross-claim against the appellant for breach, which extinguished the amount of his claim for the 2 days that he'd worked. It was somebody who was contracted for a period of time, performed only 2 days, and then left. And the issue, one of the issues then, was whether or not the employer could say, well, hang on a minute, you may have worked for 2 days, but you've caused us a lot of loss by leaving and not performing the rest of the contract. And you say, my lord, paragraph 21, as to point B, however strong the respondent's cross-claim might be, Part 2 of the 1996 Act does not allow an employer to set off cross-claims for damages against the worker against wages otherwise due. That's a feature of it being a deductions claim, whereas of course if it were a breach of contract claim, then if somebody says, well, you owe me money, it's perfectly open to the person being sued to say, well, I admit that or I deny that, but in any event you owe me money which may exceed the value of what I owe you. Because of course the genesis of all of this is protection of the worker, is to ensure that the worker is paid for what he or she actually does by way of work for the employer. And that is why, as well as the prohibition on set-off, you can only make a deduction at all if it's authorised in writing. That's what section 13(1) provides for. So even if you actually owe the money to your employer, he cannot make a deduction in respect of it unless it's authorised in the contract or otherwise in writing. And if I can for a moment take the court back to the Employment Rights Act and what I will describe as the self-contained code. It's behind tab 8 and section 13(1) is the point that I've just made, which is the one that it has to be deductions permitted in writing. But section 23 then works in the following way. Number 1, a worker may present a complaint to an employment tribunal that his employer has made a deduction from his wages in contravention of section 13. That, I say, is the subsection that bestows jurisdiction on the employment tribunal to consider the claim, because that's precisely what it does. And of course, what the court will also have observed is that it is only in the Employment Tribunal that you can litigate.
Sorry, say that again. We're on section 13.
Forgive me, my lord. So section 31.
I'm sorry, we are on section 20. Oh, but that's not part.
We'd moved on to section 23. So
Right. No, well, your submission wasn't making sense by relation to section 13, but the answer is that's because I hadn't been listening carefully. Yeah.
So section 23(1) is what bestows jurisdiction on the tribunal. A worker may present a complaint to an employment tribunal. It's employment deduction. And the point I was just going on to make, my lord, is that is the only way in which you can litigate the claim, because if you wish to turn to the last section that you have from the Employment Rights Act behind tab 8, it is section 205 of the Employment Rights Act. And it provides at subsection 2 that the remedy of a worker in respect of any contravention of section 13 and various others is by way of a complaint under section 23 and not otherwise. So when Mr Brennan says, well, you can go off to the county court, you can if you want to pursue a contract claim in the county court, but you certainly can't pursue a deductions claim in the county court, because section 205 says that you may not. And then separately, I say, at section 23(2, the Parliament deals with limitation. It provides for a limitation period, a time limit of 3 months, beginning with the date of the deduction or the end, the last in a series of deductions, and ending 3 months later. It does what it says on the tin, for want of a better phrase. What Parliament has since decided to do, and that can be seen from subsection 4A, is to apply a backstop or an arrears date in respect of deductions. That was not in force at the time of this claim, but it has since then, in order to so it was said at the time, in order to protect employers against historical holiday pay liability, brought in a backstop of 2 years and said that an employment tribunal is not, despite subsections 3 and 4, to consider so much of a complaint brought under this section as relates to a deduction where the date of the payment of the wages from which the deduction was made was before the 2 years, period of 2 years, ending with the date of presentation of the complaint. But that's not a limitation period, that's a backstop, that's an arrears date, to use the nomenclature of the equal pay provisions.
Sorry, say it again, that last bit.
The arrears date, I mean, if one looks, and I will come to Abdullah in due course, as Mr Brennan prophesied I would, the Equality Act and the Equal Pay Act talks about an arrears date as being the backstop concept. You were also, I think, taken briefly to section 27 of the Employment Rights Act, but just to make the point that section 27(1) defines wages as any sums payable to the worker in connection with his employment, including any fee, bonus, commission, holiday pay, or other emolument referable to his employment, whether payable under his contract or otherwise. So a deductions claim need not relate to a contractual payment at all.
You've got no real problem with him saying this claim arises out of the contract. In order to plead this claim, you have got to plead a contractual right. You say absolutely fine, but the fact is you brought the claim under the ERA, not otherwise.
I think, my lord, that's right. I'm rather taking, I'm rather engaging with the argument that's put against me at the moment. I think that is right. If the fact that it could be brought as a contract claim, but it's not being brought as a contract claim, doesn't assist Mr Brennan. If it's being brought as a deductions claim is what it is.
Yes, but that's your point, and that's
yes.
a good point. But it's a good point. That may be a good point, but it's not in any way damaging to that point to say that a part of it being a deductions claim is that you weren't paid money due under your contract.
Yes, but the source the ultimate source of the money, if this matters, is not the contract at all. It's a statute. It's the National Minimum Wage Act.
You're making a distinction you needn't make. I think it might well be said the ultimate source of the money is the contract, but the ultimate source of the right you're seeking, but nevertheless, the right you are seeking to enforce
Yes.
is a statutory right.
Absolutely. I don't need to go any further than say this is sum recoverable by virtue of an enactment.
Yeah.
I am entitled, or Mr Coletta is entitled to recover this money by virtue of the Employment Rights Act.
Yeah. His cause of action is a claim under the Employment Rights Act.
Precisely.
Under Section
and,
13.
And that is sufficient for my purposes.
Yeah.
But if I'm wrong about that, and you need the enactment in some way to give rise to the liability to pay, as well as being the enforcement mechanism, then that's where I say, to the extent I need to, well, actually, the reason the sum is payable at all is the operation of the National Minimum Wage Act. Because if you look at the bargain that was struck between the parties, Mr Coletta and Bath Hill Court, it provided for an entitlement to no money at all for the disputed hours, save in very exceptional circumstances. The reason why he gets anything at all is because Section 17 of the National Minimum Wage Act entitles him to additional remuneration. Therefore, I say, the fact that the mechanism by which it takes effect thereafter as a term of the contract doesn't deprive it of its character as a sum which has become due by virtue of an enactment.
Well, now, boots on the other foot, isn't it? It's never been put until now that this is really, even as an alternative, this is a claim under the 1998, the National Minimum Wage Act.
Can I be very clear, my lord, that is not the case I am advancing now. The case I'm advancing now is this is a claim by reference to the 1996 Act. But if I need to go any further, then I put my argument by reference to the 1998 Act. It is not quite as simple as Mr Brennan says of, well, it's all about looking at the contract and what does the contract provide for. My lord, to the extent that this is necessary, and if the court considers not, then I'm happy to move on. The question of what arises by virtue of an enactment is dealt with by this court in a case called the Farmerser, which is behind tab 22 in a completely different context. So, Farmerser was a case involving a company which went into liquidation, and a claim was brought against the Respondent director seeking a contribution to the company's assets. And 2 points that the court dealt with. First of all, it dealt with what was not a limitation period, because Section 214, which was the relevant provision, and this you will find at 657 letter H. If in the course of the winding up of a company it appears that subsection 2 of this section applies in relation to a person, and so on, the court may declare that that person is to be liable to make such a contribution to the company's assets as the court thinks proper. Not terribly surprisingly, the court said that's not a limitation period because it doesn't define a period of time in which the claim needs to be brought. But the court also looked at the question, and this is 661 letter E, is the claim brought under section 214 action to recover any sum recoverable by virtue of any enactment? And then Lord Justice Peter Gibson at H says on this point, I start with the question, what is recoverable under section 214? And over the page he says the basis of the claim...
So where are you reading from now?
So sorry, my lord. 661H So, having posed the question...
Yes, I see, right, got that, yes,
on
and they
this one,
ring
to
over the
start with
page.
question of what's recoverable under section 214. And he then determines at 662 the basis of the claim under section 214 is that it is to compensate for loss caused to the creditors of the company through wrongful trading. And then at letter H, I therefore conclude that 214 proceedings are for the recovery of the sum of money which the court declares the delinquent respondent liable to contribute to the assets of the company. Then does it make a difference? Does the fact the court has a discretion whether to make a declaration at all, the amount of the contribution cause the claim made not to be an action to recover any sum recoverable by virtue of any enactment? I do not think so. If one asks, by virtue of what is the sum of 1.25 million recoverable?
Sorry, I've got that. I see. I picked you up.
Yeah, if one asks, by virtue of what is the sum of 1.25 million recoverable, the answer would surely be by virtue of section 214. So here, by virtue of what is the sum of £50,000 recoverable? The answer is section 23 of the Employment Rights Act.
Right.
That is why I say this is a section 9 claim and not a section 5 claim. But going back to, well, does it matter? To what end, if I put it that way, does this dispute arise? It's because Mr Brennan seeks to contend that this is a breach of contract claim. And he also seeks to contend that you can only ever have one limitation period in respect of a given cause of action. I hope I've dealt with the first of those propositions. As to the second of the propositions, well, that doesn't in fact arise either if you're with me on the first, because if you're with me that this is a deductions claim, then this court need not, in my submission, be troubled with the question of whether in a hypothetical universe that we were arguing over a breach of contract claim, can you have two different limitation periods? Simply doesn't arise. Because as my Lord Justice Irwin observed a short while ago, a deductions claim is something different from a breach of contract claim. You go in the Employment Tribunal, and that's the only place you can go in respect of your deductions claim. You may not, depending on the claim, be able to go to the civil courts. But if you're going to the civil courts, it's not bringing a deductions claim. In the civil courts, it's bringing a breach of contract claim. It's something different. If, however, the court considers that this point arises, then in my submission there is no actual authority for the proposition that Mr Brennan has put forward. Section 39 absolutely permits Parliament to choose to enact a different limitation period in respect of a cause of action. That is exactly what Section 39
Speak
does.
up a little.
Oh,
I'm getting old.
Being quiet is not usually one of my faults, but it seems to be on this occasion. My apologies. What I was saying, my lord, was this: it is in my submission. Section 39 of the Limitation Act absolutely permits Parliament to choose to enact a different limitation period for a cause of action. For all purposes, for some purposes, it matters not. Because if one looks at the width of the language in section 39, it is not cut down, it is not restricted in any way. Section 39 of the Limitation Act says this: this Act shall not apply to any action or arbitration for which a period of limitation is prescribed by or under any other enactment, whether passed before or after the passing of this Act. There is absolutely no restriction on it whatsoever. My Lord Justice Underhill recalled the case of Stringer, in which the argument was about whether it was possible for Parliament, in the case of the Employment Rights Act, to have intended that to cover statutory holiday pay, which had not arisen as a concept until some time after the passing of the Act. And the House of Lords said, well, yes, it does. The width of the statutory language permits it. And here, there is nothing at all in section 39 that says you can only have a different limitation period if you have a different limitation for all purposes and in all jurisdictions. And the fact is that you can and you do have different limitation periods in respect of the same cause of action, whether they're litigated in the same or different fora. It's not the choice of forum which determines the limitation period. It's whether a statute passed by Parliament has made alternative provision for limitation or not.
I'm not quite sure what point we're on here. Of course, well, it can't be right. There are two limitation periods for the self-same right. How would that work?
Well,
surely the point is, you say it's not the self-same right.
I say it's not the self-same right.
Okay, but and that's easy, and then Stringer is an illustration of
Yes.
that. Or at any rate, I see. Stringer is an illustration of the self-same right being pursued by different procedures.
Yes.
So your point, I think, is in any forum there can only be one limitation period.
Yes.
I think you accept that,
Yes.
because otherwise it would be meaningless.
Yeah,
Yes.
otherwise it makes sense.
But I see, if you have what, contrary to your primary argument, is characterised as the self-same right,
Yes,
but statute gives you two ways of pursuing it,
yes,
there's nothing particularly surprising, or at any rate nothing unworkable, in each route having its own limitation period.
precisely so.
Sorry, I was being slow, but I see how you put it.
That is precisely so.
Could I come back on that?
Of
Because
course,
I
my
find
lord.
part of that I find quite difficult, and I'll need your help.
Yes,
I can quite see that if it is the self-same right, if it is, in this instance, a contractual claim, that for historic reasons and reasons of convenience, the Parliament might have said, well, if you bring it quickly, and you're bringing other rights that you can only bring if you move within 3 months,
yes,
then we want you to be able to invoke this right at the same time, so that we don't have two successive sets of proceedings arising out of the same situation. I think Mr Brennan's opening touched on that. Now, I quite see that. What I can't see is, if it is the self-same right, how bringing it within 3 months avoids the limitation period in the classic sense, so that if you get there fast, you can get 25 or 30 years of back pay, whereas if you go there up in 12 weeks and 4 days, you're stuck with a 6-year period. But that I find difficult, and I find it very unlikely that Parliament intended such a consequence.
well, my lord, if I can deal with this in this way, and of course we are at the moment dealing with the alternative case, because
Of course, yeah. And
But
I understand your primary submission is on the first point, but
yes, indeed. Because, my lord, to answer your question directly, if one looks at section 23, what section 23 says is that what one must do, if it helps, my lord, to look at the language whilst we are dealing with this point, then what section 23 2 says is that, subject to subsection 4, an employment tribunal shall not consider a complaint under this section unless it's presented before the end of the period of 3 months, beginning with A, in the case of a complaint relating to a deduction, the date of the payment of the wages, and then it makes alternative provision for a series of deductions. The first answer, I think, to my lord's question must be this, which is that section 23 is, of course, not concerned with a breach of contract claim at all. It's not the limitation period
all right, but
for a breach of contract claim. It is the limitation period for a deductions claim. I think, in fact, my lord, to deal with a breach of contract analysis, one should probably go to the Employment Tribunal's extension of jurisdiction order, which is behind tab 11. And Article 7 says that an employment tribunal shall not entertain a complaint in respect of an employee's contract claim unless it is presented A, within the period of 3 months beginning with the effective date of termination, or where there is no effective date of termination within a period of 3 months. So that's the time limit in which you have to bring the claim. But Article 3 provides for some fairly important restrictions on the ability to bring a contract claim. A contract claim in the Employment Tribunal has always been a very limited thing. Proceedings may be brought before an Employment Tribunal in respect of a claim of an employee for the recovery of damages or any other sum if A, the claim is one to which Section 1312 of the 1978 Act applies, and which a court in England and Wales would, under the law for the time being in force, have jurisdiction to hear and determine. B, the claim is not one of the excluded claims, and C, the claim arises or is outstanding on the termination of the employee's employment. So Parliament has chosen not to require the claim to be brought until 3 months from the termination of employment, but the breach has to be one which is arising or outstanding on termination of employment. So if it's a historical breach, and say it's a historical breach and you've waived it because of the passage of time, then you won't be able to bring the claim in the Employment Tribunal in any event. So Parliament has provided protection for the employer by saying the claim has to arise or be outstanding on termination of employment. It is, I venture to suggest, very unlikely that a breach of contract that occurred 7 years prior to the termination of employment could be said to be outstanding on the termination of that employment. But the other point, my Lord, perhaps is this, is that by subsection A, a court in England and Wales has to have jurisdiction to hear and determine that breach of contract claim. It's a precondition of being able to bring the claim at all. So what might be said is that is the mechanism for bringing limitation into a breach of contract claim in the Employment Tribunal, because the court has to have jurisdiction to determine it, not because...
Well, we all know that the Limitation Act doesn't go to jurisdiction.
It doesn't. It does in some cases, but in any event, this perhaps is not directed. Well, it's certainly not directed at the primary case. What I would say, however, in relation to Lord Justice Irwin's question to me is, do I say that you can have a different time limit in respect of the same cause of action? I say yes, you can, because my primary argument would be to say that insofar as it arises, the order prescribes a different period of limitation. If you look at Article 7, what you have to do is bring the claim within 3 months of the effective date of termination. But in any event, there are other examples where precisely that happens.
Well, if you're going to give some other examples,
And that
I see it's 2 minutes to 1.
yes,
Why not give them after lunch?
of course, my Lord.
2 o'clock.